Hello! In this clip from our Justia webinar, Navigating and Mitigating Ethical Conflicts in Estate Administration and Planning, Leah Del Percio will talk about the impacts of conflicts on the legal practice. If you want to see more Justia videos on law practice and legal marketing, be sure to subscribe to our channel.
Questions to raise when you're bringing on a new client and you're trying to figure out where conflicts could be potentially. So the first is what capacity are you representing the client in? So here I say capacity. I don't mean state of mind or, whether the client's of sound mind. What I'm referring to here, are you representing them in their individual capacity, like me, with respect to, just my own personal net worth, family issues, etc.? Or are you representing me as CEO of my company? Two very, very different and distinct roles and different quote unquote capacities. Or are you representing me as beneficiary of, my parents' estate, or in my role as a trustee of someone else's trust? You need to keep these in the back of your mind all the time. Obviously, adjust your engagement letters to limit your scope there. Really important, so that if, say, you end up having a really good relationship with that new client that you brought in, they want you to work with them on other matters. Each time, okay, I represented them as a trustee here. Now I'm doing their estate planning. I'm representing them individually. I need a new engagement letter to go out for them with that work. So really limiting the scope. If you have to send multiple engagement letters, that's what you have to do. Those are important things because God forbid you need to wall off some of that. You don't want to necessarily, there may be some that are waivable, some that are not waivable, and you want to keep your options open so you can continue to have a positive relationship with that client over time as your practice grows. The next big factor is connectivity. What connections do the parties have with each other? And I don't just mean with when you're representing joint parties, but rather what connections do, me as CEO of my company have with, my business partners or my family members? How does that interrelate with my estate planning? How does that interrelate with employees or investors? These are all things that are important to look at depending on the capacity that you're representing someone. So in the executive space, or if you're advising a company, you're going to want to look at, those business relationships versus personal and sort of be able to delineate them in your mind. For fiduciaries, you're going to look at the beneficiaries, and are they family members? Are they, kind of more at arm's length? Are these business relationships? Are they personal relationships? Who is a fiduciary? Who is a fiduciary and a beneficiary at the same time? All important things to keep in the back of your mind while you're doing this work, and adjust your engagement letters accordingly. Okay, what's the worst that can happen with conflicts? So, the consequences of conflicts of interest, attorney discipline. You can get sanctions, grievances, be reprimanded, and even up to being disbarred for certain types of conflicts. Many of us see this frequently, particularly if we're in litigation, but in no area is it more common than in the trust and estates and sort of like individual private clients space. Disqualification, you can disqualify yourself from the work. That's fairly, straightforward as we think about it. And then Rule 11 sanctions and malpractice liability. If you're having any of these, you're certainly, at risk of being sued for malpractice. So it's important to always kind of keep that one. It's more under the umbrella of malpractice in a way than just a line item here. But just important to be mindful of that this could be a combination of all of these things. So it can be serious. It doesn't feel serious when you're like initially bringing on a new client and everything's wonderful, and the sun's shining and the birds are singing and you're happy to bring them on and they seem wonderful and their family gets along and it's going to be great and they're going to refer everybody to you afterwards. But Let me tell you, that can get really hairy and not be a good situation as you progress with that client. And even those things may seem wonderful when that client dies in 20 years and you have a lot of concurrent conflicts of interest or successive conflicts of interest, the situation doesn't look as peachy. So just important to be thinking about this stuff ahead of time, foreseeing, and I hate to be doom and gloom here, but all the issues that can come up and protecting yourself, as that attorney, since you are a fiduciary for your clients. So now we're going to look at, what the RPCs say for current clients, former clients, and then sort of the law firm versus attorney. So we'll start with current clients. So current clients. So this is all dealt with in Rule 1.7. Except as provided in paragraph B, a lawyer shall not represent a client if the representation involves a concurrent conflict of interest. A concurrent conflict of interest exists if the representation of one client will be directly adverse to another client, or there is significant risk that the representation of one or more clients will be materially limited by the lawyer's responsibilities to another client, former client, or a third person, or by a personal interest of the lawyer. Notwithstanding the existence of that concurrent conflict of interest, here's where it gets waivable. The lawyer may represent the client if the lawyer reasonably believes, that the lawyer will be able to provide competent and diligent representation to each affected client. The representation is not prohibited by law. The representation does not involve the insertion of one claim by one client against another, again, where clients are suing each other, by the lawyer in the same litigation or other proceeding before a tribunal, and each affected client gives, and this is an and, so this is required for a waiver, each affected client gives informed consent confirmed in writing. Now, what does informed consent mean? That means the client has to be fully disclosed of the conflict, the potential implications of it, and they also need to know that in so doing, they can obtain separate and independent legal counsel to advise them on the actual waiver document. That piece is extremely important. It needs to be black and white and outlined in that waiver document. So just important stuff to note, and we'll get to that, in a little bit. So that's concurrent clients. Now let's look at former clients. And this is always an interesting topic to me because, when does representation actually end with respect to trust and estates clients? So, one thing to touch upon is dormant representation, which is going to be the majority of cases. So long as the scope of the representation is narrowly defined, and again, that's being very clear in your engagement letter, I'm representing you to draft your estate plan right now. This is not an ongoing representation that I have with you and an ongoing fiduciary obligation I have to you as your lawyer next year when your estate planning documents have been signed. That representation ended upon the signing of those documents or the funding of those trusts, really outlining it black and white, crystal clear for that client, the start and the end of the representation. And if they want to use you in ongoing and in existing matters, which is the goal, do new engagement letters for those additional pieces or addendums. To that, so long as the scope of representation is narrowly defined, the execution of estate planning documents and the completion of related matters, such as changes in beneficiary designations and the transfer of assets to the trustee of a trust, normally ends the period during which the estate planning lawyer actively represents the estate planning client. At that time, unless the representation is terminated by the lawyer or the client in advance, that representation becomes dormant and awaits activation by the client, i.e. it awaits that client coming out and saying, hey, I need you to revise my estate plan. I had another kid, or I'm getting divorced and I need a new estate plan. Or my financial situation changed, or hey, I just feel like changing things. That's the activation in the future, for that client. So you may wonder, and often I always advise attorneys to hold on to the original physical will and trust documents and store them for the client, because I can tell you how many situations I've seen where the client requests their original documents. They're like, I want to hold on to these. They put them somewhere, whether it be the junk drawer in their kitchen, or their underwear drawer, or God knows where. They write on the documents, which can render them, create probate issues down the line. Really big no-no. But, writing on original wills, they're crossing people out. I think for those of us who watch the TV show Succession, good example of that, where the main character, crosses out his kid's name, but it kind of looks like an underline. That's actually far more common than you think, and why I always advise clients to actually hold on to the original will documents, whether it be a codicil, wills, any testamentary document, including trusts themselves. Give the client an electronic copy with a stamp on it of where it's held. Have a fireproof vault for these purposes, so they come back to you and they formally update things, and make sure and that way you can assure that they've been signed with the right formalities, and are done properly. People like to write on their documents. So anyway, off of that aside, you may wonder if holding on to those testamentary documents actually continues your engagement. And I will say that, the ACTAC has commented on this, because it's a valid concern. Although the lawyer remains bound to the client by some obligations, including the duty of confidentiality, the lawyer's responsibilities are diminished by the completion of the active phase of representation. So, even if you're storing it, it's still dormant, I think, is where you can sort of safely make an assumption for that. As a service, and I certainly did this when I was in private practice, and the tax laws changed, particularly related to the estate tax exemption going up or down, or being gone or coming back, and different trust rules changing and things like that. So as a service, lawyers may want to periodically communicate with that dormant client regarding, the new changes to these laws, which are ever evolving because they're a political hot topic, and, the desirability of, reviewing those estate planning documents. Super common. That does not mean that you represent that client again. That representation stays dormant. You're also not obligated to send a reminder to that client on these updates. It's nice. And hey, it's a great way to continue that relationship, continue to build trust with that client on sort of as their ongoing counsel on these things. They clearly are going to look to you for this stuff. But it doesn't, it keeps that representation remains dormant until they come back out and say, hey, yeah, I want you to revise my documents now. So sending form letters, pamphlets, brochures regarding changes in the law, are completely fine, and aren't going to bring that representation into an active mode. It will remain dormant. So now let's look at what the RPCs say about joining new firms. So, this is more law firm versus attorney, these imputed conflicts. So if you're joining a new law firm, how do you navigate this? So the first step is to identify those potential conflicts of interest. Law firms, especially if they're large, they typically have systems in place to track all their clients and matters handled by each attorney at the firm, and they have a conflicts group that can help identify any potential conflicts. If you're a smaller firm or you're teaming up with another solo, you probably don't have this, but what you do need to do is go through all your client matters together. There's always been this big ethical question that's sat in my mind that I would love the answer to if anyone has, of your duty to keep your client matters confidential and the identity of your clients confidential. Many attorneys and law firms interpret it that way, but there seems to be this free pass when you're doing these conflict of interest checks where you're forced to write the whole list of every client you've ever represented to identify them so you can do a conflicts check. I don't believe there's any hard and fast rule in the model rules or any state rules that I've looked at that shows that as an exception to that confidentiality duty. But it seems to be standard practice that for that limited purpose, you can give them the names of your clients just to check and make sure there's no conflicts there. So just important to note, you should feel safe in doing that, but make sure that that document, once the conflict check is done, is secured. In a confidential manner and disposed of. If you do find conflicts, whether you're a solo, you're doing this manually, or working with a conflicts group, it's important to properly inform that client about the situation, the potential impact it could have on them. You want to tell them, here's what could happen, because they represent this person and I represented you. They're relying on you. You're in a position of trust to them. And this is confidential stuff. So if there's another attorney in there in the firm that was working on something that could be adverse to them, whether material or not, the client needs to know that. They need to understand and be able to foresee how that could affect them in the real world. So you then also, again, that's part of having informed consent, which we'll get to. And then the possible need for them to seek separate and independent counsel now that you're sort of at this new firm dealing with this, or you have this new attorney coming into your practice and you're trying to navigate this piece. Then there's screening procedures. So if a conflict arises due to an attorney moving to a new firm, whether they're bringing in a conflict from a prior client at their old firm, there may be screening procedures that the new firm brings on and implements. That might be walling off data. So it might involve isolating the attorney, making sure they can't see other types of client matters, or that other group, say that the conflict since in can't see that trust and estates matter. Many firms, particularly large ones, do this as a matter of course. There's very specific protections to even be able to look at trusts and estates or private individual clients as opposed to the broader firm. So that's certainly one way of doing it, is just standard default. Nobody in the corporate group or the commercial litigation group can even access any files for, the trust and estates or private client practice groups. So those are things just important to keep in mind too. But they might just wall off the data if they don't do that as a matter of course. Informed consent. This is where you're getting that waivable conflict. You're letting the client know, again, the informed part being the key there, on so many different levels, and seeing what the client decides to do. You also, in a situation where maybe informed consent isn't going to work, the conflict is too great, you may need to decline, continuing to represent that client or withdraw from the matter. So, that does happen too, and is just important to keep in mind. You also need to consider, the ethical rules. Every jurisdiction has their own set of ethical rules. It might be different than the model rules. So always consult, your state's ethical rules, that, how your state's adoption of the model code. Again, because we live in the US and every state is its own place and has its own little nuances that are deeply and critically important. Document actions. So this is where you're going to document any actions that have taken place to address this conflict, where the conflict arose, how you see it, what the implications would be, and then the steps you're taking to either waive it, or the client's taking to waive it, or whether you're declining, how you're walling off data, all of that. All really, really important to do.
Thanks for watching. We hope you enjoyed this video, and if you did enjoy it, please hit the like button and subscribe to our channel for more law practice and legal marketing videos. See you in our next clip.